it's Judicial Watch taking the lead on both of these. In California, the biggest companies in the world didn't want to take it on. The little old Judicial Watch did, David versus Goliath, and we won. So we had some major victories in California in the last few years on a variety of issues. I already talked about election integrity, but California state, the state of California passed into law, the left did, a series of laws requiring private corporations, more or less, to put people on their boards of directors based on race, gender, and other improper quotas. So they wanted to codify, or they sought to codify, and did, and we challenged these laws, race, sex, and other discrimination in the selection of board members for private companies. And what Judicial Watch did is that we filed lawsuits on behalf of taxpayers to stop this woke discriminatory quota schemes that were being mandated against companies in California. And I think what's interesting is that I don't think any company sued to stop it because they were afraid of the left-wing mob. And so it was Judicial Watch who came in and did the heavy lifting. And we won. We had 2 courts in California find these laws to be unconstitutional under California law, contrary to law. But California continues to spend taxpayer money to try to resurrect these woke quota schemes. And so as a result, Judicial Watch continues the battle. We filed this massive brief in court the other day, 87 pages, 87-page brief. Our lawyers worked for weeks on this, trying to defend the rule of law in California to prevent, in this specific case, a quota scheme from being resurrected as a result of an appeal that would require discrimination against men in the selection of board seat members. As the headline we know, let me get the press release up so I can show you the press release. California seeks to revive failed corporate board gender quota. Judicial Watch announced today it filed a 90-page brief in the California Court of Appeal defending a California trial court ruling striking down Senate Bill 826, SB 826, the state's controversial law requiring publicly held corporations headquartered in California to meet government-imposed gender quotas in their boards of directors. So obviously we encouraged the Secretary of State's appeal to be knocked back and to stop and ensure that taxpayer money isn't spent to implement or enforce the law because it violates the California's Constitution. The brief urges the court, as I say in the release, or as we say in the release, to uphold the lower court's decision permanently enjoining California Secretary of State from spending taxpayer money to implement or enforce the law because it violates California's Constitution's Equal Protection Clause. And this was not an easy victory. Our team was out there for a month of trial. Senior government officials in California were required to testify. You had experts on both sides, providing information to the court. As we say in the brief, after 27 days at trial, 16 witnesses, 174 exhibits, and a trial transcript that spans over 8,500 pages, California Secretary of State was unable to convince the trial court that the gender-based quota satisfies one of the toughest standards the law imposes, strict scrutiny. The law has multiple failings, not the least of which is that it was never intended to remedy alleged patterns and practices of discrimination in the board selection processes of some 625 publicly held corporations headquartered in California. We filed this case back in 2019. Law was passed in 2018, and we shut it down. We won that trial. The law was sold to the legislature as a way to increase women's representation on corporate boards, if not achieve gender parity, and therefore boost the California economy and protect taxpayer shareholders and retirees. Because gender parity, economic benefits, and protecting taxpayer shareholders and retirees have never been compelling government interests under strict scrutiny, the Secretary needed another justification for the law when it was challenged in court. But because the legislative groundwork for a remedying discrimination compelling state interest had not been laid and never could be laid, that effort failed. It should have come as no surprise that the Secretary was unable to defend the law's gender-based quotas despite having every opportunity to do so. So this is my layman's understanding or translation of what the brief says. So strict scrutiny means if you're going to engage in discriminatory conduct as a government or require such conduct, it has to be really directly tied to discrimination, a remedy for discrimination that's been shown and very narrowly tailored. So, if you get fired because of your race, you get hired back and you get the money. Or they find that applicants for a certain job were thrown out. The applications were thrown out on the basis of race. They say, okay, well now you've got to consider them, and so that's what I mean by you can consider race in the context of a remedy for absolute discrimination. Saying you want more women on boards because you like it, because it makes us feel good, because it's good for business. That's not allowed under the law. That's no basis to start discriminating against men in favor of women in the selection of board seats. And as I said earlier, the businesses were willing to let this happen because they didn't want to fight the Borg. The left Borg, as I call it. It's a Star Trek reference. Look it up. And it was Judicial Watch that came forward with our brave taxpayer clients to take this on. And in a fierce battle in trial, win. So to be clear, there was no discrimination to remedy. As we highlighted at the trial, the number of women on the boards of California's publicly held corporations was increasing before the passage of the law. So there wasn't discrimination against women. And as we say, she makes no effort, the Secretary of State does, to show that the law was designed as nearly as possible to restore the victims of specific discriminatory conduct to the position they would have occupied in the absence of such conduct. Meaning they couldn't have, there was no woman who came forward and said, I could have been on that board but for my gender. Because it wasn't happening. Indeed, the lack of any effort to limit the benefits of the scheme to those who actually suffered from specific discrimination will be fatal to the scheme. meaning the quota would end because there's no one they could help. SB 826 plainly is a quota and a rigid one. The Secretary's own expert described SB 826 as a quota. One legislative report called it essentially a quota system for private corporation boards. Quotas are illegal in most every measure. And the state, in pursuing this, they weren't involved in discrimination. The evidence wasn't presented they were involved in discrimination. There was nothing to remedy. No quota was necessary. And here's what I said about it in our press release. California continues to waste taxpayer dollars defending the indefensible, an unconstitutional gender quota scheme imposed on corporations that only serves to help corporations virtue signal about hiring women for their boards through government-mandated quotas. The trial court correctly concluded that the state failed to satisfy the demanding constitutional standards required for government discrimination based on race. The Court of Appeals should affirm the ruling and reject California's attempt to rewrite the purpose of the law after losing a trial. So this isn't the only lawsuit we have. I talked about the other lawsuits. So they passed the gender quota law, and then they passed another law that expanded the quota system to include race, ethnicity, sexual preference, and transgender status quotas for corporate boards. So I wouldn't say doubled down. This is, it's just beyond belief that they would think they could get away with this. So the first gender quota law was passed in 2018. They followed up with the max quota law to include all these other classifications that are improper to mandate discrimination on the basis of in 2020. And in 2022, we won again. The Superior Court issued a ruling and an opinion striking down the bill, thanks to Judicial Watch's lawsuit, and granting a permanent injunction prohibiting the Secretary from spending taxpayer money on the unconstitutional law. So I suspect that fight's going to go on for a bit too. You know, so this highlights how your Judicial Watch is when it comes to like constitutional civil rights, one of our nation's preeminent watchdogs, or guard dogs, really. I mean, you have the state of California mandating this crazed quota scheme or schemes foisted onto private corporations, publicly traded. So if you are an investor in a corporation, you're in California, you would have been impacted by this more directly. And it was a brazen embrace of discrimination. I'll say it once, I'll say it again. The left endorses discrimination. They believe in it. They use it. They will go to court to protect it. And they will discriminate against you if you are the wrong classification of sex, race, etc. In Evanston, Illinois, we've got this class action civil rights lawsuit to stop a reparations scheme that gives out money based solely on race. There's other factors. You have to be a resident or have a family member who is a resident of the town during a certain period. But you don't have to prove any discrimination. You just have to check the racial box and you get the $25,000. A similarly situated white doesn't get $25,000. Justice Department has followed our lead and is joining or seeking to join that lawsuit. So despite all of the noise you hear about how, oh, the left is nervous or about and moving away from DEI and these woke schemes, they're not. California is fighting us tooth and nail in court to mandate government discrimination or enforce discrimination against people on the basis of sex. Evanston, Illinois, giving out money based on race. And again, it's Judicial Watch taking the lead on both of these. In California, the biggest companies in the world didn't want to take it on. The little old Judicial Watch did, David versus Goliath, and we won. So thank you for your support. Let's hope the courts uphold this. I'll keep you updated. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.